The latest display of political violence comes almost 2 weeks after Democratic Congresswoman Pramila Jayapal's life was threatened outside her home in Seattle. The man was released from jail days later. And on top of all of that, the continued protests outside the home of U.S. Supreme Court Justice Brett Kavanaugh, now lasting for about 2 months. Professor Alan Dershowitz, author of the book The Price of Principle, joins me. Professor Dershowitz, Alan, first of all, the Bannon conviction. If this is treated like an ordinary case, 2 misdemeanors in the District of Columbia, at most probation. What do you think of this verdict, and what do you think of what's likely to happen to him?
Entirely predictable and entirely in violation of the Constitution. The only provision of the Constitution which appears basically twice is trial by jury, in front of a fair jury. Number one, he didn't have a fair jury. Number two, the judge took his defenses away from him. The judge denied him a jury trial. They wouldn't allow him to put on evidence that he believed that there was an executive privilege involved and he wanted a judicial determination before he violated the executive privilege. That issue could not be presented to the jury. So as I predicted on this show and other shows before, the conviction was a foregone conclusion. The only issue is, will it be reversed by appeal, either by the appellate court in the District of Columbia or by the Supreme Court? I think it's very likely that this conviction will be reversed at some point.
I suppose the political overlay is the obvious. I mean, I always like juries, respect juries. I've tried cases before juries in this community, sure. But this is a community of 94% Democrat.
Well, not only that, but probably 97% Trump haters. And all you had to do is, ladies and gentlemen of the jury, this man Bannon worked for Trump. That's the end of the case. And then he wants to put on a defense that he was executive privilege. And the judge says, no, the jury is not going to hear that. So even if there were a fair jury, the judge denied the jury the basic facts. And so the issue in this case has always been a legal one. When Congress holds somebody in contempt and that person invokes privilege, do you get to prosecute, or do you have to go to a judge first, get a judicial order, and then if the defendant violates a judicial order, obviously that becomes a crime. That didn't happen here. That didn't happen in the Navarro case, and the Supreme Court's going to have to resolve that issue. And I think it will resolve it in favor of requiring a judicial order before Congress can hold somebody in contempt. That's a major constitutional issue.
As an aside, I've always liked the juries here, respected the juries, and they didn't hear all the evidence because the judge only had certain rulings that, as you noted, limited the amount of evidence. All right, now, turning to the Congressman Zeldin, he's had that threat. Justice Kavanaugh has threat. We've had Congresswoman Jayapal. I mean, you can't eat at a restaurant in Martha's Vineyard. People get arrested for doing, attacking people, scaring them, threatening them, and they get released. I've always fought for bond, but this is out of control.
Well, I think you have to make a distinction between people who object to me or Kavanaugh in front of their houses. They get bail. But when you have somebody coming up to a congressman with a weapon, at the very least, you hold him for enough time to determine whether it was part of a larger plot, whether he was really violent, whether he's likely to do it again, whether he has any kind of mental illness. Automatic release does not seem proper. Judges have enormous discretion. They hold people all the time in pretrial detention who are not at all dangerous, who didn't use any weapon. And here you have a judge saying right away, let him out. The discretion is too great, the disparity is too great, and the danger is too great.
Well, with Congresswoman Jayapal, the person was released from jail, had a gun, said, go back to India, I'm going to kill you. And then the prosecutor said there was lack of evidence to bring a hate crime. And I'm not sure, I mean, I don't know why there's a lack of evidence if he says, go back to India, I'm going to kill you. I mean, that certainly seems rather hateful to me. And let the jury decide that, not the prosecutor.
No, I agree with that. That seems like it crosses the threshold into a hate crime. I'm not a big fan of hate crimes, but they're on the book. And if they're on the book, they should be enforced. But this Zeldin thing is just tragic. I mean, here's a decent guy trying to make a speech from the back of a truck, and all politicians today are going to have to look over their shoulders, whether they're playing baseball or they're making a speech or they're at home having written a Supreme Court decision. That's not the way America ought to be. We went through this in the 60s with the Kennedys and with Martin Luther King. I was hoping we were over that. And so far, None of them has resulted in death, but it's only a matter of time if the culture continues to produce. You talk about hate crimes. We live in a hate country. People hate each other if they disagree over politics. And that's just not the way to build the kind of country that Abraham Lincoln wanted to build when he said, "Divided we fall."
It's a little different statute. The 1507 is a federal statute. Says that if you protest with the intent to intimidate a judge or influence a judicial opinion. And yet, I interviewed former Attorney General Bill Barr. He said that he would indict people for what they're doing outside Justice Kavanaugh and some of the other justices' homes because that would be their intent. Would you? I respect the First Amendment, but to me, that statute says with intent, and I don't know why they're at their homes otherwise.
Because it's probably unconstitutional. The Supreme Court has held in a number of cases that judges have to have thick skins. If you intimidate jurors or witnesses, that's one thing. But if you're a judge for life, a justice for life, you have to have thick skin. And so protests in front of the home for justice may well be constitutionally protected. It's a close case. It's a close case.
But how do you test the constitutionality without at least making an initial arrest so that we can bring it up through the court system?
Yeah, you could do that. You can bring some kind of declaratory judgment. But in the end, that statute will have to be tested. And I think it will uphold it as to vulnerable people like witnesses and jurors. And the question is, will it uphold it to life appointment judges? I don't know the answer to that question, but I think it's a hard question.
You know, it's that intersection of the Constitution, which you and I both admire so much, and so many others do as well, and respect for the First Amendment, and then the powder keg, where you get a bunch of people together and they're saying horrible things, and some of them are armed. It's just not, it's not a good situation. On both sides of the political spectrum, and we're living in very dangerous times. Indeed we do. Professor Dershowitz, thank you, sir.
Thank you.